Good morning. I declare open the committee's public hearings for the inquiry into Victorian Planning Provisions Amendments VC 257, VC 267 and VC 274. Please ensure that all mobile phones have been switched to silent and that background noise is minimised. I welcome any members of the public in the gallery or watching via live broadcast. I remind those in the room to be respectful of proceedings and to remain silent at all times. I would like to acknowledge the traditional owners of the land on which we meet and where these proceedings are being broadcast, and I pay my respects to their elders past, present and emerging, noting that the land has never been ceded. All evidence taken is protected by parliamentary privilege as provided by the Constitution Act 1975 and provisions of the Legislative Council standing orders. Therefore, the information you provide during the hearing is protected by law. You are protected against any actions for what you say during this hearing, but if you go elsewhere and repeat the same thing, those comments may not be protected by this privilege. Any deliberately false evidence or misleading of the committee may be considered a contempt of Parliament. All evidence is being recorded. You will be provided with a proof version of the transcript following the hearing, and transcripts will ultimately be made public and posted to the committee's website. For the Hansard record, can you please state your name and the organisation you're appearing on behalf of? Thank you.
Yeah, thank you. My name's Andrew McKeegan. I'm the Deputy Secretary of Planning and Land Services from the Department of Transport and Planning.
And my name's Colleen Peterson. I'm the Head of State Planning, sitting underneath Andrew in Land Services, Planning and Land Services.
Thank you very much, and thank you for appearing today. My name is David Edershank. I'm the chair for this select committee. I'll just invite the committee members to introduce themselves. Perhaps Mr. Davis, starting with
Davis.
you.
Georgie Crozier.
Bev MacArthur.
Sarah Mansfield.
Sheena Watt.
Michael Galea.
Brian Batchelor.
So thank you for joining us today. It's much appreciated on what I know is very short notice. We'll allow about sort of half an hour, if that's okay, to get going, and then we'll move into questions. So please, thank you.
Thank you, Chair. Colin and I propose just to run briefly through the slide deck that we've provided today, and hopefully that will support the committee in its considerations of the Victorian planning provisions as just outlined, and against the planning provisions of Victoria. I'll just run through the first few slides in relation to the strategic context and setting in relation to the provisions and also the sort of structure of the planning system. Then I'll hand to Colleen to go into much more detail around each of the provisions in their nature, how they're implemented, the objectives and the consultation undertaken. I too would like to acknowledge the traditional owners of the land in which we're meeting here today and pay my respects to elders past, present and emerging, and extend that to any Torres Strait Island and Aboriginal people with us here today. So to kick off, first of all, I'd just like to talk you through the strategic intent documents that underpins the decisions in relation to the planning provisions. And the first one of note here is the housing statement. And in addition to the housing statement, another key document, which I don't actually have on our slide deck, but also worth noting, is the National Housing Accord that was signed by all jurisdictions in relation to housing supply. But in relation to the housing statement, I would like to note that in September 23, the Victorian Government released the housing statement, The Decade Ahead, in response to housing affordability issues in Victoria. The housing statement signals the need for increased housing supply with key initiatives including reforming Victoria's planning system, increasing housing close to transport roads, hospitals and schools, delivering a long-term plan to guide Victoria's growth, and delivering vital community infrastructure. Some of the key government commitments that relate to the provisions we are discussing today are clear planning control to deliver an additional 60,000 homes around the initial 10 activity centres across Melbourne, streamline assessment pathways including the deemed to comply residential standards for different types of homes, unlocking new spaces to build including across established suburbs to boost supply and stop sprawl, and creating places where people live, have vibrant, livable and sustainable communities close to public transport and jobs. I'll take you to the next document and strategy of relevance, and that's the Plan for Victoria. Released on the 28th of February 2025, the plan sets a statewide vision for how Victoria will grow over time. The plan is structured around 5 key pillars, housing for all Victorians, accessible jobs and services, great places, suburbs and towns, sustainable environments, and self-determination and caring for country. The pillar that we've called out today and have on this slide is in relation to housing for all Victorians and delivering sufficient affordable homes for all Victorians. So the focus here, as set up on the slide, is about more homes, ensuring that we have enough homes to meet the forward demand over the next 30 years, ensuring that those homes have great diversity. It's really important to ensure that we have housing choice and that the housing choice is spread throughout Victoria in the appropriate locations. Make sure that that diversity, as I said earlier, is focused around public transport and jobs, and to ensure that those properties are as affordable and fair for people to be able to access those homes in various locations. There is also now the focus of this plan moving away from the previous plan for Melbourne being a Melbourne-centric plan to being a plan for the whole of Victoria, and has significant focus also on regional Victoria, both jobs, employment and key projects within those regions. And the last point up there around innovation and building solution, to make sure that the planning system is modern, thinks about new forms of building, modern forms of construction, and ways in which we build our houses to make them more affordable and better designed and environmentally sustainable. Importantly, the plan reinforces the long-term policy objective of achieving 70-30 split, consistent with the earlier plan for Melbourne, and also establishes housing targets for local government areas to enable them to support the growth of the Melbourne plan and work with the state government in relation to delivering the plan. I won't go through each of these objectives, but obviously this is important to your considerations in that you were considering the three provisions against how they meet the objectives of the Planning Act, and Section 4.1 sets out those objectives. But I won't go through into reading each of those, but it's just worth noting that's obviously a key part of what today is about. And then in relation to the planning provisions, so I just thought it was worthwhile just touching briefly on the planning provisions themselves. And so Part 1A of the Act establishes the planning provisions. The purposes of the VPPs is to provide a consistent and coordinated framework for planning schemes in Victoria. It's a statewide reference used as required to construct the planning scheme. In simple terms, I like to see it as the sort of the state rulebook and the way in which we can bring together a whole range of provisions. You'll see on the right-hand side there the key components of the planning provisions. And importantly, two of the provisions that we'll talk about today are actually new zones within the toolkit or within the library. And ultimately those zones can be applied by any planning authority at any future time through a planning scheme amendment. So they're not necessarily just a once-off sort of change to the structures of planning schemes. They are a new tool that could be applied within those planning schemes over time as and when required. It's a statutory device to ensure consistency and they are prepared from a statewide basis, often because there is a policy or a position need to be taken that rather than having every individual planning scheme amended, it's a more effective and efficient way to have that done through the planning provisions and implement that across all of the planning schemes. This slide really just talks to the structure of planning schemes. So the Act provides for each municipality to have its own single instrument, effectively its planning scheme. The planning scheme is a legal document prepared and approved under the Planning and Environment Act. Each planning scheme must seek to deliver the objectives of planning in Victoria within the area, setting out objectives, policies and provisions relating to the use, development, protection and conservation of land in the area. It regulates the use and development of land through planning provisions to achieve those objectives. Importantly, they have a combination of statewide, regional and local policy in each of those schemes that get implemented through the planning schemes. And then the final slide from a sort of structural perspective and strategic side of things is the how planning schemes gets amended. So it's important there to note that the planning authority, which can be a local council, it can be the minister, the Suburban Rail Loop Authority is another planning authority, just an example. It's the responsibility of the planning authorities to undertake the work. In relation to the three provisions we're discussing today, the minister was the planning authority, a note worth pointing. there are clear ministerial directions and also guidance in relation to how those matters are exhibited and noticed. And in relation to exhibition and notice, under Section 20, Part 4, the Minister may exempt themselves from the notice requirements, and that did occur in the case of these three provisions as well. So on that note, I'll hand over to Colleen to step you through each of the planning scheme amendments and talk to them in more detail.
Thanks, Andrew. This is where we get stuck into the ticky-tacks of the three amendments that you're interested in. So the first amendment, which was VC 257, introduced two new tools within to the Victorian planning provisions. So as Andrew said, these are effectively a zone and an overlay, the housing choice and transport zone and the built form overlay. And they're a standard set of controls that are added into the Victorian planning provisions that can be applied as a planning authority may see fit. I think it's important to recognise that Amendment VC 257 did not in of itself apply the controls to any land in Victoria, but really put them into the toolkit. It is fair to say, though, that a recent amendment on Friday, GC 252, did recently make changes to 12 metropolitan planning schemes that did apply the housing choice and transport zone and the built form overlay in relation to 10 activity centres. That was part of the pilot activity centre program. And just so you're not confused, the reason why it's 12 local government authorities but only 10 centres is because Moorabbin, which is one of the centres, actually sits in 3 metropolitan councils, so very confusing for that centre. Amendment VC 257 was required so that, inconsistent with the Victorian Housing Statement, it creates a suite of planning tools that can be implemented to support the development of additional housing in and around activity centres and in other well-serviced locations. And by the creation of that tools, it provides certainty to communities, landowners and the development industry. So the tools are designed not just to be used within the activity centre program, but can be used more extensively. And the department's already receiving inquiries from other municipalities as to how they may be able to use these controls in particular circumstances in their own municipalities. The provision of that additional housing in activity centres, it really is part of contributing towards the long-held state government policy of delivering 70% of housing within its established urban areas. As Andrew's indicated, that was first introduced into the planning scheme in 2002 as part of Melbourne 2030, and it's also consistent with very long-held state policies around urban consolidation, where there's an acknowledgement that it is more economic, more sustainable to provide housing in locations where there is already established infrastructure and services. And those policies have been in the planning scheme far longer than I've been practising as a planner. Now, the key features of the housing choice and transport zone is firstly for it to encourage a diversity of housing within the catchments of these activity centres and other well-serviced locations, particularly where there is convenient access to jobs, public transport and services. Importantly, this zone does not introduce any changes to third-party pathways, including notification or the ability to be involved in a VCAT appeal. So those controls remain in play. It's intended to be applied to residentially zoned land that's within easy walking distance of the key transport node. That would typically be a railway station. And the distance typically would be an 800-metre walking distance. So you'll see from some of the plans you may have seen, it's not a radial distance, it's quite a site-specific distance, recognising the location of railway lines, for example, that inhibit walking routes. The built form overlay is a standardised overlay that is typically would be applied to the core of an activity centre, and that is land that would be typically zoned for commercial land uses. It's designed to be able to be modified through a schedule to provide guidance around building heights, setbacks and other sorts of public realm initiatives, including overshadowing. It introduces a streamlined pathway that allows more homes to be built faster and does include exemptions from notice and review provisions. However, just to put it into some sort of context, each of these 10 centres are located within commercial zones that prior to the introduction of the amendment, and certainly the GC amendment on Friday, already had exemptions from notification and third-party appeal rights. So the introduction of this within the BFO is not a new concept. These centres were already subject to third-party exemptions and appeal rights. In terms of how does the amendment further and enhance the objectives or implement the objectives of planning in Victoria, you'll see in the green box, these are the ones that we believe are particularly advanced by the amendment themselves. And look, rather than read them out, I'll just sort of speak more generally. But the controls that these give effect to really enable the planning schemes to facilitate the development of additional homes in and around activity centres and in well-serviced locations, really as a direct response to the housing crisis that is set out in Victoria's housing statement. So as an example, the amendment facilitates development that is fair and orderly to the planning of land because it is consistent with well-held and state policy around the urban consolidation of land, particularly around well-serviced locations. That principle is interwoven through not only state policy but regional and local policy as well. It creates more sustainable housing by locating that housing close to public transport, reduces car usage, and it obviously has flow-on implications not just for congestion but for carbon usage. It creates less pressure, or alleviates some of the pressure to expand the urban growth boundary and containing the urban form of Melbourne, and it will provide for more affordable housing, both through the additional of more housing in general, and we know that additional housing does relieve price pressure, but also through the inclusion of a public benefit framework in the BFO that does allow, where there are mandatory controls, for those controls to be exceeded, providing public benefits such as affordable housing as it's prescribed within the Planning and Environment Act to be provided. The controls provide certainty for all stakeholders, including the community, making it clear that activity centres and their walkable catchments are the primary focus for increased densities in Victoria. And that enables the state government to balance the interests of both present but also future Victorians, recognising the need for more housing in well-serviced locations. If we think about then how that is applied to land, and we can perhaps look at that in the context of the GC amendment, that's an understandable consequence. It will support the integration of state policy by providing this well-located integrated housing. It provides social benefits by facilitating more housing close to jobs, transport and services. Supports improved housing affordability by facilitating additional housing supply and choice of housing type. And of course has economic benefits to state and local economies. For example, the reduction in travel time because people live within close commutable distance to their jobs. Now, I appreciate that there may be some conjecture around the impact of supply generally on affordability. And while I'm not an economist, I'm an avid reader, and the Grattan Institute has done a lot of work in this space. The Grattan Institute's research shows that if we provide 50,000 more dwellings a year over a 10-year period above and beyond what is expected, that will have a 20% reduction in the price of both rents and housing prices. So that information gives us confidence that if we improve the supply of housing in general, that does put downward pressure on housing, recognising that the solutions to particularly very low and low income earners needs to be dealt with separately, but in terms of the broader issue of housing affordability, supply is certainly part of the solution. If we then turn to the consultation on Amendment VC 257, there was, particularly in the context of the Activity Centre program, really quite extensive consultation that was undertaken, and we received more than 10,000 responses across those 10 communities, including council and industries, across 2 phases of consultation. Now, the first phase was in March and April 2024, where we did receive those initial 10,000 submissions across all 10 centres. There was a second phase of engagement in August and September last year, and at that consultation we issued draft plans that gave an indication of what sort of built form outcomes the department was considering for those 10 centres. Now, during that particular phase, we had very targeted consultation, particularly with the councils in particular, but also with industry, and that included not just the built form outcomes, but also the planning tools that were being proposed. So that include all 12 councils in question and a number of industry representatives. Now, it's fair to say that for 5 of those activity centres, they already had some fairly well progressed strategy plans and design frameworks in play, and that strategic work was critical and an important component of providing advice to the state government in the work that was ultimately pulled together. So there was quite close working with those councils to adopt and implement that work. Of the 5 activity centres, and that was implemented on Friday. It's fair to say that for those 5 councils that had undertaken that strategic work, they had also undergone a substantial amount of consultation for those centres. From memory, that was Camberwell, Preston,
But
Frankston,
not the catchments.
Ringwood, and I'm a little hazy on the 5th one. Sorry, I'll come back to you with the 5th one. In August 2024, the Minister for Planning appointed an advisory centre standing advisory committee, and she referred a number of key matters to that committee, and they included matters that were raised through the consultation process and through the submissions to the program. The SAC considered those matters, including some other matters that were put to them, questions that the state government was particularly interested in getting clarity on, and relevant changes were made to the program, and as I said, that was put into place last Friday. I should say that holistically, the introduction of new tools into the planning scheme, such as the housing transport zone or the BFO, are typically done without a formal public consultation process because they are tools that are put into the planning scheme. So whether it's the residential zone reform, whether it might be a whole range of state-led projects, but it is quite common for there to be no official consultations part of that because it is simply a tool that is part of the kit. Consultation may be more typically found through the implementation of the tools. When we look then at VC 267, and this is an amendment that implemented the Townhouse and Low-Rise Code, it effectively replaced Clause 55, which has been colloquially known as Res Code, with the new Clause 55, now known as the Townhouse and Low-Rise Code. What makes it different to the previous Clause 55 is that it only applies to development up to and including 3 stories. Instead, Clause 57 has been created, and that applies to 4-storey medium density housing. So there's been a decision to break 4-storey housing away. There's also been a number of consequential amendments to residential zones and schedules that enable then the policy objectives of that townhouse code to be put into place. Now, these changes have been introduced as a response to the significant time and cost delays associated with the delivery of relatively low-rise, medium-density housing across Victoria. And it recognises that this lower form of housing has been largely embraced by Victorians as attractive places to live, and that can be more affordably delivered and provide more diverse sizing and generally are located into good proximity to all forms of infrastructure. It's estimated that the reforms will reduce the average time from 145 days for a decision to comfortably be able to sit within the statutory timeframe of 60 days. And of course, there are additional delays if an appeal is lodged against a council decision, and that can often take another year. Now, the key features of the code is that it facilitates quicker and more efficient decision making through a series of deemed to comply pathways, recognising that about 18 months ago, the state government already made 13 of the standards deemed to comply. And so half of the code has effectively been on this deemed to comply pathway for some time. In the new provisions, if the applicable standards are deemed to be met, then the application is exempt from third-party review rights. However, applications are still notified to surrounding owners and occupiers as per typical practice, ensuring that communities remain informed about the development in their neighbourhoods, and ensuring, for example, that design response are accurate, and where not, that they are corrected so that compliance with the standards can be tested. Now, of course, where there is non-compliance with a standard, particularly around issues of neighbourhood character and external amenity, those third-party appeal rights remain enlivened. So where something directly affects an adjoining property owner and there is non-compliance with a standard, they are still able to be party to and take a matter to appeal. This approach, the government believes, creates greater transparency and certainty, not just for applicants and decision makers, but also for the community. There's now clarity around what is acceptable within these residential areas. Remembering that there are 8 standards that seek to ensure that neighbourhood character has been positively responded to, and there are 5 standards that seek to reasonably protect the amenity of adjoining neighbours. Now, another key feature of the new clause is that there are now 7 standards that relate to ESD credentials of buildings, and of course there are now 12 standards that relate to minimum internal design standards for dwellings to ensure that the standard and level of accommodation being provided is appropriate. In terms of how 267 intersects with the objectives of the planning and the objectives of planning, you can see here in the green box again, these are the 5 standards that we think are reasonably met by the amendment itself. But particularly it relates to faster and quicker decision making around medium density housing development. As I've said before, greater transparency for applicants and the community about what is and is not acceptable. It becomes very black and white, and of course how it will be assessed. It will ensure that development is more sustainable and the reasonable standards of amenity for existing and new residents will be achieved. It brings medium density housing in line with the expectations for higher levels of housing, which are currently in clause 58. So things like room dimensions, the level of cross ventilation, room depths, for example, ensuring that the quality of this housing is of a high standard. And of course, it provides improved requirements for ESD and internal amenity. These include standards around solar panel protection, the requirement for there to be appropriate room for the location of new solar panels, cross-ventilation, waste management, and of course tree canopy. It facilitates the objectives of planning in Victoria by streamlining that assessment and providing a better environment for Victoria's community, and that's a better environment on a number of levels: sustainability, livability and the like. In terms of VC 274, it inserts the precinct zone into the VPP. So again, it's another tool that has been added into the Victorian planning provisions. And that, of course, makes consequential changes to the provisions to give it effect. Again, VC 274 doesn't apply the zone to any land in particular, but it has been designed by the state government to be able to be implemented by authorities as deemed appropriate into the future. And obviously the current public exhibition that the SRLA are undertaking is an example of that. Now, the PRZ is designed to be applied to facilitate substantial changes in use and development across priority precincts in response to the housing crisis, but also to stimulate economic growth. It's not applied to any land, but instead becomes another tool in the toolkit. Now, the PRZ is a special purpose zone and has been developed because it has become evident in the last 2 or 3 years that the existing suite of zones in the planning provisions didn't provide an appropriate framework when reimagining substantive renewal areas. So the precinct zone provides a consistent framework where planning authorities can really set out the sort of framework required to realise a strategic vision for a precinct. And that's quite different to other zones which are really designed to be developed in areas that are already quite established. The schedule in particular is important because it is the schedule itself that will enable the planning authority to translate the objectives of that strategic work. The classic example would be a structure plan into the objectives of the scheme. So the zone itself is really just a very blank canvas. It's the schedule that does the really fine tuning of what the vision will be. Under the precinct zone, an application to most matters is exempt from third-party notice and decision requirements. There is, however, the ability for the schedule to turn that on. So it's not a blanket exemption, but the planning authority can decide to turn it on or off. But again, turning off that exemption is commonplace, and we see it in pretty much all of Victoria's existing urban renewal areas. That would include Fisherman's Bend, the Central City, Arden, Macaulay Arden. There are a whole range of whole-scale precincts where third-party rights are turned off, and that's because the work is done through the structure planning process. As I said before, the zone is not applied to any land at this time, but it is seen to be the tool that will facilitate the development of the 6 precincts across the SRL East, with an estimation of 70,000 new homes across those 6 centres. And again, in the cores of those centres, they will be affected predominantly by commercial one zone land, where that land, where those rights are already turned off. In terms of implementing the objectives of the zone, again, you can see it here in the green box. I think it's fair to say that the zone will really facilitate and guide the use and development of land. It supports the integration of well-located, diverse housing that meets community needs, provides social benefits by delivering more housing close to jobs, services and transport. Again, supports housing affordability through facilitating additional housing supply. Again, noting that the precinct zone has a public benefit uplift provision, so that where mandatory heights are exceeded, then there's a requirement for there to be some public benefit, of which affordable housing is a tool that can be used. And of course, economic benefits for the state and local economies. In terms of consultation for VC 274, again, because it is a tool within the planning scheme, there's no consultation directly consistent with state government practice, but there is extensive consultation being undertaken at the moment with regard to the 6 centres with SRL. Those structure plans are actually on exhibition. I think they close on the 22nd of April, and there will be public special advisory committee hearings to be held, I think it's September and October this year. So I hope that presentation's been of assistance to the committee. It helps you understand the strategic context for the 3 amendments, the objectives of the Act and how they intersect with the Victorian planning provisions. And Andrew and I, of course, are here to take any and all of your questions.
Thank you very much. That's really appreciated and very timely. I might kick off briefly and go from there. Looking at 267, I'm interested in a couple of things. There's a reference to planners and others not being required to consider other things. That's a very passive expression, not required. Should the committee understand that that actually means shall not consider?
I think that's fair. The way that the documents are written is to say that where a standard is met, the objective is met, and therefore the consideration around that particular matter is deemed to comply. And so therefore the council or another responsible authority such as VCAT doesn't need to turn its mind to other matters relating to that particular objective.
Okay, so that's the panel, or that's the tribunal's
Or a
switch
council.
off. But the switching off of, well, actually, let's go to deem to comply first. So am I correct in understanding, for example, then, that if a development proposal under 267 is being considered and it is deemed to comply with the standard, effectively council or the planning authority is precluded from including in its assessment any other policies that the council may have through the planning scheme? Is that correct?
That's right. So a completely deemed to comply proposal that meets all, I can't remember, 30 objectives or some 30 objectives, it effectively means that a permit must be granted.
So in that sense, the regulation is not the minimum in terms of the deemed to comply regulation. It's the totality.
Correct.
And effectively objectors and councils are sidelined from the process. Is that reasonable?
Well, I wouldn't say sidelined, but it provides certainty about what is and isn't permissible. I think it's fair to say, though, for example, where there is non-compliance with a standard, then policies in the planning scheme that relate to that standard, let's say it might be site coverage. Site coverage falls within the neighbourhood character suite of provisions. That would mean that all the policies in the planning scheme relating to neighbourhood character can be considered by the decision maker.
Even though the project itself is deemed to comply?
No, that's if there's non-compliance
okay,
with
yes.
that standard.
All right, sorry I missed that.
Yes.
All right, so then I guess one of the questions that strikes me is in terms of things being switched off, am I correct in understanding that where it's deemed to comply, there's actually no requirement for either notice or third-party appeals?
So there's still the requirement to provide notice. The Planning and Environment Act stipulates that where there may be material detriment, then an application should be advertised. In effect, what that means that any medium density housing application, no matter how small, is advertised. So that advertising process still remains in play, but where it is deemed to comply, there are no rights of review.
Okay, and there's no way to object to a development?
You can object, and the council will take those objections on board in determining whether or not there is compliance with the standards.
So if it's viewed that it's met those standards within the deemed to comply model, basically at that point in time, council's really got nothing to look at, has it?
Well, the council is required to issue a planning permit. But perhaps to just be a more fulsome answer, if an objection might include concern that their property hasn't been accurately portrayed on the design response plan and that the difference in levels between the properties hasn't been accurately conveyed and therefore there's not compliance with the side setback requirement, the council would absolutely take that into consideration in determining whether or not the standard is met.
Okay, thank you. Looking at one of the ones that's sort of doing my head in a little bit is the exemptions to clause 55. And so it says, as I understand it, that section 61B, E and F are not required to be considered, or effectively shan't be considered.
Yes.
So 61B is the objectives of planning in Victoria.
Yes.
So effectively what this amendment is saying is that the objectives of the Act itself are exempted from the decision-making process.
That's where it's a compliant application.
Right. Okay.
So what the wording tries to do is that ensure that where an application is compliant, that a council couldn't, for example, take other policies in an attempt to refuse an application. That is the intent of those provisions.
Okay, yep. So I guess I'm sort of looking at the task before the committee, which is to assess these amendments against the objectives of planning in Victoria. And one of the amendments we're looking at exempts the process from the objectives of planning in Victoria. Am I missing something there, or are we sort of chasing our tail to some degree here?
Well, it's about providing certainty that makes it clear to all parties that where an application is compliant, that a permit must be issued. So it's not about trying to undermine the objectives. The objectives of the Act are deemed to have been met if an application is compliant. So that is where the connection lies.
So all of that is really premised then on having a high level of confidence that those standards in fact cover the field.
Yes, I think that that's a fair synopsis.
And so, but there's also where there might be disagreement by stakeholders, such as councils or community. There is no provision or ability to seek to reinterpret that, because that is effectively both the minimum and the maximum standard. Is that correct?
That's right. There'll certainly, I think, be debate about whether or not standards have been met, and I imagine that there will be ongoing decision-making and precedent set through councils and the tribunal over the coming months about what compliance with various standards look like. But yes, where a standard has been met, there is effectively a tick against that particular criteria, and the decision-maker moves on to the next standard and objective.
Okay. And did I understand you correctly when you said that the 10 existing activity centres, so in the previous planning scheme, that all of those were exempt from any third-party appeal rights with regard to any development that might happen within that activity zone?
It's more nuanced than that, but certainly the majority of these centres, well, they're all either predominantly zoned commercial 1 or in the activity centre zone. So both of those zones effectively have third-party exemptions and appeal rights for buildings and works. So you would, for example, advertise an application that involved a use that required a planning permit. So an example of that might be, I'm trying to think, something that's reliable. It could be a hotel, for example. So you would advertise the use, and that the use would be open for interpretation, but not the built form outcomes. Probably the main difference is that the current controls, certainly in the commercial 1 zone, do have a 30-metre buffer to residential or sensitive zoned land. That's probably the main difference. But the concept of the development of land being exempt from third-party review rights in commercially zoned areas is not new.
Okay. Thank you very much. Mr Davis.
Chair, thank you, and can I thank both of you for your presentation. There's a couple of prior things, just a little bit like the Chair. You've mentioned some of the subsequent amendments that have been made. There was one made correcting some errors to one of the planning amendments, and then the GC one that you mentioned just before. Is there any other amendments that have been made since these 3 that we're looking at have been gazetted? Is there any other amendments that impact them other than those 2?
No, and obviously the SRLA precincts that are currently on exhibition.
But they haven't actually been implemented as
No, as I said, they're on exhibition.
Yeah. So it's just those 2
Yes.
that are changes. The second thing, I just want to be clear about that and make sure that we weren't missing anything that might have an impact. The second thing I have is when the Minister made these amendments, the department would normally present her with some materials to support that. Is that
Yes.
That would be the
She'll
normal.
be briefed.
It would be helpful for us to have a copy of that material that was presented to her, supporting or underpinning the decisions that she made in these amendments, and the GC one as well.
We'll take that on notice and find what's appropriate we can give the committee.
I'm sure it's appropriate. It's releasable under FOI. I've done that
Yeah,
before,
I'm
so
happy to provide the committee.
we would appreciate that in quite quick time, because the basis of the decisions is actually quite an important point to understand. The other thing is you've looked at these activity zones, and the 10 plus 50. Is there any work that's been done looking at the required infrastructure, the capacity of the required infrastructure in these zones? Do you have an analysis of sewerage, schools, health services, public open space that's required in each of these zones?
Yeah, so within the 10 activity centre zones, there was quite a bit of work done in relation to identifying infrastructure needs and working through, and the Minister recently gazetted a ministerial direction in relation to the ability to use an infrastructure contribution plan for those 10 activity centres.
So there actually is another amendment that's relevant.
That was a ministerial direction in relation to development contribution plans. And sorry, in relation to your question, we're referring to the actual use of those provisions. This is about allowing an infrastructure contribution plans to be applied for those 10 activity centres. And that looks at the various types of infrastructure needs, as you've discussed there, to determine what would be appropriate for those activity centres to be able to be rolled out with infrastructure. And
so is there analysis behind that set of decisions?
So there's work done with the local government and councils to identify the types of infrastructure that would need to be considered within that. That obviously is a combination of state and local infrastructure, and so that would need to be worked through with the councils and the state over time for that type. But there's certainly a standard selection of the types of infrastructure that you would normally see within those types of areas. And
some of these are very big increases when you add the catchment zones around as well. They're very, very big increases. And what we appreciate is that material that you've got that deals with each of the 10 zones and indeed the 50 as well.
So the standard types of infrastructure that would be expected to be collected within those areas.
But you'd
and
actually have to have a
information,
particular examination of each of these, I would have thought.
So the way the infrastructure contribution works is there's a standard menu of
Just, can I
infrastructure
step you
type.
back from the infrastructure contribution? This is about examining the capacity of the area and what's needed to support the proposed dwelling numbers.
That's right, yes.
Yeah, so infrastructure contribution may be one part of it, state contribution, even council contribution may be part of
three
it
parts,
too.
that's correct.
But you must have some capacity assessment of each of these 10 plus 50.
Yeah, so the work in relation to the activity centres was to firstly focus them in locations where some of those core infrastructure capacities already exist. So, making sure that we're capitalising on significant infrastructure that already occurs within those locations. It's then about saying what additional impact does sort of residents have within those areas, what types of infrastructure needs would come within those areas, and then that
So
would
do
help
you
lead
have
towards
those
an infrastructure.
documents for the 50 plus 10, the 60 centres? Is there work on each of the 60 centres, and can we have that, please?
Certainly the work for the 10 pilot ones, I can take that on notice and I'll have to look into the broader
Can we,
program.
and the 50 as well? Is there
I'll-
work on the
I'll-
50? Is there
That work hasn't commenced yet.
So that work hasn't commenced. So Q has been declared, but the work to look at the capacity needed to support the amount hasn't commenced.
Which is the program to roll that out. So we
Right, so
started with the 10.
you've kind of put the cart before the horse. You've declared it before you've done the capacity work, as I'm understanding it.
No, that's not how I would put it. So what we've done in a sense of a capacity sense for the next ones is to look at and this is about the integration of the Department of Transport and Planning, it's to look at the corridors where there's significant uplift capacity within our public transport networks, to look at the ones that meet the same
with
criteria.
with
And-
respect, it's not just about transport. This is about health, and it's about education, and it's about open space, and it's about sewerage. So if I can pick an example, Hawkesburn has been declared an activity centre, one of the 50. You're telling me there's been no capacity assessment done there on the shopping centre, the sewerage, the schools, or health services nearby? None at all.
Yeah, I'm probably happy just to add on from Andrew here. The rationale with the 50 centres is to provide a range of centres that have differing potential for development. So I think it's fair to say that some centres, and Hawkesburn's probably a good example, will have less opportunity for significant change than others. But the whole purpose of having a range of centres in the program is to establish a model by which other councils can then take that work.
With
and
respect, can I just interrupt you there and just say, actually, what you're actually
Davis.
telling me...
Mr.
what-
Davis,
yes,
I think we'll just let the witness finish the question.
yes, but
from
I'm
there.
actually
I'm
trying to get
conscious
to
of
the
time.
No, you're
point
not.
that they've proceeded in a case like Hawkesburn
before the horse.
without
Haven't made any determination.
actually having done the capacity assessment
I think it's-
previously.
Okay, please.
Where is it?
All the 50 centres do is identify as activity centres in which structure planning will be put in place. What that structure planning looks like in terms of capacity for housing and heights and the like will be determined through the programming, and the ability of infrastructure and upgrades will be part of the information that will help shape the physical outcomes of the centre. Just because a centre has been included doesn't automatically mean that it will be subject to significant height changes. As I was saying, that the whole purpose...
But the planning amendments apply now.
No,
the planning amendments haven't applied to those. So they've only applied to the first 10. And I guess what I was trying to
You don't
say
know
is,
what's going on, Mr. Davis.
No, I'm trying to get this out.
no, so the work that was done within the first 10 went into the detail of that work. The rollout of that program has identified activity centres that are able to be considered in the same way. So we still need to work through that program, just like we did on the first 10 with the local councils, understanding their needs, understanding the growth, and then that program comes through in the sense of those areas.
No
as well.
capacity assessment done
All
at all
right,
on the 50. Thank
We'll
you.
take that one as a comment. Thank you. Mr. Gaia.
Oh, thank you, Chair. Thank you very much, Mr. McKeegan and Ms. Peterson, for joining us today. I'd just like to start with the whole theme and objectives of planning that's been touched on. I know we had touched on with some earlier questions about compliance with planning objectives in this state. Would I be right to say, though, that these planning scheme amendments have in fact already passed that compliance by the very fact that they've been introduced? So would the process of then having to go back and then recheck everything again, would that just be double doing the process and wasting time?
Certainly, the government has formed a view that the three amendments themselves absolutely advance the objectives of planning in Victoria. When you look that in the context of the strategic setting, so whether that's the National Housing Accord, Plan for Victoria, the soon-to-be gazetted Plan for Victoria Housing Statement, there is a clear and consistent messaging about the need to provide more housing in areas that have great access to infrastructure and other services. That has been the cornerstone of decision-making around residential land use in Victoria for around 35 years. There is nothing new in the concepts that are being more broadly implemented by these controls. The mechanisms obviously are new, and we appreciate that there will take some time for these to work through the system. We need to obviously bring the community on board, support councils in how they implement the tools, and we're working very closely with local government in that area. But yes, we would say that absolutely that they do further the objectives of planning in Victoria.
And obviously, as you say, it has been for a long time. I recall Melbourne 2030 was talking about densification in certain areas and limiting urban sprawl. We've seen much talk in this space for, as I said, well over 30 years, and Dr. Stephen Rowley's commented that as well, that it's been a very long-term objective of the planning schemes to bring that urban densification and consolidation as opposed to the urban growth, but we frankly haven't seen it to the extent that we'd like. I was speaking with a friend's son yesterday, a 19-year-old apprentice tradie who's obviously one day wants to buy a house himself, but also from the outer suburbs. He said to me, talking about what I was doing today, and he said to me, we can't keep expanding into farmland as well. Areas such as where I represent, Casey, Cardinia, but others all around Melbourne as well, in my view, have taken by far and away disproportionately the brunt of Melbourne's population growth. Do you have any data or figures to go through how this malapportionment, I guess, of housing has played out in current years and in recent years in those outer suburban areas, and how the outer suburbs have been disproportionately taking the share of housing growth in this state?
We certainly know when we track the share of housing being built in established areas as opposed to the growth areas that it's been probably 50-50 for some time. Obviously, that's a long way from the 70-30 goal. We know that it will take some time to transition to the 730. We don't expect to, click our fingers, introduce the reforms, and in a year or two that goal will be met. But we need to put the planning mechanisms in place so that, particularly in the next year or so, as the development industry, the conditions become more ripe for larger scale, taller development to occur, that those planning schemes are in place. We know, as you've indicated, that there are incredible pressures on the urban growth boundary, and those pressures are real. We have food security being a real intangible goal. I think about, the vital importance of the Kooyarop Swamp and the role that it plays in food production Victoria. We obviously have the land in and around Werribee. That these are vital resources that we need to protect to ensure that Melbourne is sustainable in terms of its food supply, but also sustainable in terms of time and commute times, the cost that has not only economically but socially, the fabric that pulls on families in terms of time wasted in travel, and of course the carbon footprint that infers by people driving when they could be living in smaller houses closer to services and walking or taking public transport, cycling.
Thank you. And in terms of the levers that the state government can pull, you touched on this just briefly before. Obviously, the state government can't set interest rates. The state government can't determine material prices. They're a global market. Planning is one of the main levers that the state government can pull, and obviously there's all sorts of various different factors. But when market conditions do allow, how important is it that these amendments, these planning rules will be in place to enable Victoria to build more houses, to house more people and provide more chances for young people, such as my friend's son, to get into the property market?
Yeah, look, absolutely. It's really important. The role within planning that we focus on and the role that we can play is all about creating supply in diverse locations. So ensuring that the ability because the government, other than through Homes Victoria, doesn't build homes. As you point out, we don't control a whole range of that private market. But if we can focus on supply, creating opportunities in the right locations, giving as much diversity of that through from infill right through to greenfields, because as you point out, people are at different cycles of their life. And I know when I was in my 20s, I was happy to be in a share house, and now with 3 kids, there's no way I could. So
Probably not, no.
various ways through, you always have that different. But it is important that we create that supply, the opportunity, and have the private sector and people that want to invest and build homes are able to do that. Then even if the market's not right now, if they can get those permits, they can work that through the system, and when the market does turn, then obviously they're ready to go and be able to construct those homes, which is obviously pretty critical in those locations.
Thank you. And in terms of going back to the basic objectives of Plan for Victoria, the housing statement, how do the activity centres in particular relate to that, and how important are they to the success of these housing reforms?
Yeah, so they were a key element within those both of those key policy documents, and it's about, again, making sure that we have appropriate supply, maximising what is an incredibly good public transport system in this state. It's one of those advantages that we have, and we really need to capitalise on that advantage. So having those developments and housing opportunities in and around and close to public transport, it means that the life cycle cost of those properties can come down. You can, consider active transport and using that facilities rather than needing to rely on private vehicles and other things. So it is important that we create supply in locations. And as I said, it's about housing choice. Not everybody wants to live in that arrangement, but there are plenty of people that do. The ability to downsize, the ability to stay in a suburb that you've lived in your whole life, all of those matters relate to the way in which you can give that housing choice in and around those existing suburbs.
Thank you. Now, we know that despite some rhetoric, the activity centres aren't an open slather across all of inner city Melbourne. In fact, we've already had some submissions to this inquiry calling on the government to do more. In terms of the consultation is very important. Can you talk to me about how that's influenced the activity centres? I know there have been some modifications made in a number of activity centres already based on that local feedback. Can you talk to me a little bit about that process and how that's played out?
Certainly the consultation process, and I think we need to talk about this in the context of the 10 pilot centres. As I said, we've had 10,000 pieces of feedback, extensive community consultation, targeted feedback with specific councils. I think it's important for us to say there's been really proactive and collaborative working with local government on the activity centre programs.
Really?
Not on the catch.
I know City of Kingston, excuse me, Mr MacArthur, I know City of Kingston have been very involved in the process. One of my local councils with the Moorabbin Activity Centre, and again, very keen to
That's right.
to get the
I
most
appreciate
out of it.
that there is, just perhaps to follow on from some of the comments. I think how the catchments have been treated is an excellent example of how the department and the minister has taken on the feedback of communities. So initially the concept was to treat the catchments effectively as the same. You'll see now that there's housing choice and transport area 1 and 2. Area 1 is the area closest to the rail and the activity centre. It's about a 10-minute walk. That allows for development up to 6 stories in height. But let's be really clear here. In order to get above 4 stories in that zone, you need a site that's firstly greater than 1,000 square metres and needs a
There's heaps
frontage
of
of
them.
more than 20 metres. And so that means that you need larger sites. Those sites are better able to ameliorate the off-site amenity impacts. I think it's fair to say we have analysed all the lots within the housing choice and transport zone. Only 3.5% of lots exceed 1,000 square metres in size. Now that varies slightly from centre to centre. Some
Correct.
are higher, some are lower. But on average, only 3.5% of lots exceed 1,000 square metres. So it's a very small number.
Okay,
Thank you very much. I'd love to deep
We'll
further,
leave
but
it there, and Dr Mansfield.
Thank you, Chair, and thanks for appearing today. At the start of your presentation, you mentioned that the Minister exempting themselves under Section 24 of the Act from having to go through the usual exhibition and consultation requirements for a planning scheme amendment was common for tools, but usually when it comes to implementation, they do follow those steps. Amendment VC 267 essentially does implement a change right across the state, but that was also exempted from those processes. So that, I guess, is a bit of a departure from usual practice. Some of the changes we've already learnt under section under VC 267 are quite significant. Mr. Edershank touched on that. You've said that the exemptions in particular are based on the premise that the deemed to comply standards are robust enough, in your opinion, to meet the objectives of the Act, and therefore that doesn't have to be considered. How can you be certain of this given there was no consultation with, for example, council town planners and other parts of the sector? Or at least you didn't go through that usual exhibition and consultation
I think it's
process.
fair to say that the government didn't traverse the normal consultation process, but there absolutely was consultation with local government. Local government was very strongly represented at every stage of the consultation process. We had a technical reference group. We had local government participation on that technical reference group. We met with them regularly over the 2 years, and they were instrumental in refining and developing the standards and the operational characteristics of the code. In the 7 workshops that we held with industry stakeholders, local government was very heavily represented, both rural, regional and metropolitan councils.
Who by?
All councils were invited to attend, and many councils represented. I can't give you a list off the top of my head, but I can take that on notice and give you a list of council representatives. But there was absolutely fulsome engagement with local government.
And were local government specifically consulted during that process on the list of those exemptions, those specific exemptions that
Yes, it was
are
made
outlined?
very clear from the outset that this would be a deemed to comply process, and that the ultimate outcome would be effectively the process that we now have in play.
Okay.
So it was very transparent from the outset that this would be a fully deemed to comply process.
Okay, and so if I'm to understand these exemptions correctly, for example, there are a number of councils across Victoria, the CASB councils, I guess you'd call them, that have signed up to that, who may have higher ESD standards than what is specified in these under the new Res Code. Those higher standards can no longer apply to new developments meeting that requirement. Is that correct?
So we've actually met with the CASB councils last week. We'll be doing further work with CASB as a whole. I think it's fair to say that the provisions within Clause 55 are a stepping stone in implementing the ESG roadmap, and we are working with those councils to see how we can encourage further excellence in environmental sustainability and medium density housing. So there is still further work to be done. The government acknowledges that, and we're hoping that we'll have that in play before the end of the year.
Okay, but as things stand at the moment, it's potentially brought some of those councils down, like they're going to have to lower their ESD requirements potentially for some new applications.
That's right, in the short term. But we also see that, for example, the building regulations play a critical role given a number of the sustainability objectives are building-related matters. Mm-hmm. So we see it as a more fulsome solution to the ESD situation.
Okay. Another consideration that is it's common practice at the moment for if there's a planning application made, decision makers will have to take into consideration overlays or planning scheme amendments that maybe haven't been finalised but are sitting on the minister's desk waiting sign-off. A flood overlay, for example. Under these deemed to comply standards and the exemptions, is it correct to say that those things that previously would have had to be considered no longer have to be considered? So say there's a draft flood overlay that hasn't been signed off by the minister for an area, provided it meets deemed to comply standards, the decision maker doesn't have to take into account that work.
So certainly for existing overlays, they absolutely remain a fulsome
Yeah, I'm
part of
talking
the
about those
assessment
ones
process.
that have gone through the process but are awaiting sign-off.
That's right.
Previously,
Yes.
would have had to be taken into consideration.
That's right. So technically speaking, that's right. An amendment that is what we would call seriously entertained. It's gone through the panel process and is waiting that final level of either adoption or gazettal. Technically can't be considered. But for example, in the instance of flooding, in a draft flooding amendment, that work is still captured under the building regulations, and so a building permit can't be issued unless it meets and reflects the requirements of the flood study. So while it's not caught in the planning requirements, it will still be caught under building.
Okay. But there may be other overlays or
Yes, just
planning scheme
specific to
amendments that, the next day might be approved, but if it was deemed to comply the day before,
Correct.
that doesn't have to be taken into consideration.
That's right.
Okay. You've also, you alluded earlier to some data about how these proposals will, increase supply of housing and also make housing more affordable. What modelling has your department done to demonstrate that these changes will deliver that?
In terms of the Activity Centre program, there's been detailed work looking at the capacity of the centres. In terms of the townhouse code itself, we haven't done any specific modelling per se because the possibilities are almost infinite when you look at any property that is of a reasonable size, has the opportunity where it's not affected, for example, by a heritage overlay where there's always going to be demolition controls, that there is the opportunity for substantial increase in supply. So to some degree that modelling is quite meaningless, so it hasn't been undertaken.
Okay. I guess, a strong justification for all of these planning scheme amendments, and I imagine some subsequent ones that we will be seeing, is that it will deliver more housing supply, that essentially deregulating some aspects of the planning system will deliver more supply and that it will deliver more affordable supply of housing.
So for example,
I guess what I'm trying to get at is what evidence are you basing that on? You mentioned a Grattan Institute piece previously. Is there any other modelling or evidence or work that the government has done to develop?
There's extensive
this argument.
economic research that shows that increase in supply puts downward pressure on prices.
Can you provide some of that?
If we-
Thank you.
We'll take that on notice.
Thank you.
In terms of the townhouse code itself, there are 1.45 million lots in Melbourne alone that are in the residential zones. So just thinking about it in terms of, this is why I say that the modelling could be meaningless. If just 10% of those lots, so 1 in 10 lots, built 5 townhouses, so 5 townhouses on an 800 square metre lot, pretty uncontroversial in terms of scale and density, you get a net increase of 4 dwellings on a lot. That's 580,000 dwellings in metropolitan Melbourne. So you can see that the code itself, in providing certainty for housing supply, absolutely has the potential for increased numbers of housing right throughout metropolitan Melbourne.
Thank you.
Okay, thank you. Ms. Crozier.
Thank you very much, Chair, and good morning, and thank you for appearing before the committee. Just a couple of things, Ms. Peterson. I want to challenge you in relation to the consultation that councils have been provided with, given a number of councils in my electorate have significant concerns. And I want to read this to the committee that was provided to me from council and goes to the issue around catchments. The release of the draft plans, particularly the inclusion of the catchment areas, has unfortunately caught most councils, including ours, off guard. The lack of information provided to council, combined with the lack of response to our comments, combined with a very short period from submitting comments to the release of the drafts on the 22nd of August, gives us little confidence that there was any intention to genuinely consider stakeholder feedback. The speed of this process undermines the collaborative efforts that are essential for effective planning and community outcomes. Now, to go to Mr Davis's point and to go to concerns from community, this has not been undertaken in an appropriate manner, I don't believe, and councils are very concerned about that amenity. I want to take you to the economic analysis that has been undertaken, or what have you done for the city of Boroondara that has got roughly around 70,000 dwellings now, and that has been over the last 190 years since European establishment. And yet these targets are going to put a further 65,000 dwellings into this area in the next 20 or so years. So given the lack of consultation for councils, given their concerns around these catchment areas, given this huge uptake of dwellings, what economic analysis has been done for particular areas, and is this really feasible?
Are you talking about the economic analysis, or are you talking about the housing modelling?
No, exactly, both. It is there's got to be some economic analysis of what you are doing to these areas, given the council's concerns, their lack of consultation, as they say. They've had very little input. They're concerned about amenity and what analysis has been done. Clearly from the response to Dr. Mansfield, it's the modelling or other aspects haven't really been followed through.
In terms of economic modelling, the concept of building more increased densities in and around activity centres does not in of itself really need economic modelling, given it's been the cornerstone of state government policy for 30 or 40 years. There's certainly been quite extensive housing target modelling, and we can take on notice to see what we're able to provide in that particular area. But certainly my feedback is that the City of Murundara are actually comfortable with the housing targets that have been set. How they're implemented might be another conversation.
Are you kidding
I
me?
don't think that's
Are you
right.
kidding
That's
me?
nonsense.
Why do you say that?
Because the feedback that I've had from the
From
activity
who?
centre team,
Well, who's on the activity centre team?
well, Natalie Reiter when she was in charge.
Who else?
She was the Deputy Secretary.
I tell you what,
Okay.
I mean,
70
We're
and
actually
another
in the community.
65,000, there's no support for that at all.
No, I'm talking about the council is comfortable with the target. How, as I said, how it's implemented.
They had a different target.
Correct.
The target.
Now, I'm going to move on. I'm going to move on because I absolutely object that. I object to that assessment that you make, given the discussions that we have with council and very good council officers within that council. The 10 plus 50 activity zones recently declared. Can I ask, what has the department done in terms of the estimates of how many dwellings will be added to each one of these activity centres?
That work is still being undertaken.
So you haven't even done that? You're just putting this in place and you actually haven't even done that work?
No, so the work in relation to the 10 has been done as the 10 pilot.
With the 10 pilots?
Yep.
So could we have a table of those, the number of dwellings for each of those, please? And then could you please provide a progressive for the remaining 50 zones? Or what if any work has been done?
Yes, happy to.
We'll take that on notice. I think just in terms of the work being done for the 50 centres, that work is all about to commence, and the interplay between dwelling numbers, building heights, infrastructure, that will all be developed over the next 18 months. So we haven't gone into the process with preconceived targets or building heights in mind.
But-
it is
but-
something that we
Change the
build.
planning rules.
You've changed the planning rules. The government has a housing target and you
No,
haven't
we
done
haven't.
the work.
Only in
we
those
haven't
10.
changed.
Res code changes have. They have impacted.
But for the 50 centres that are in the second tranche and third tranche of the
Res
activity
code
centre
impact.
program, there has been no change to the zone controls or the overlays that affect those centres. Yes, the changes to clause 55 may increase some dwelling density in some of the residential precincts, but that is separate to the 50 centre program.
It's everywhere. Yeah.
Yeah, it's all over the place. You mentioned Fisherman's Bend, Arden Street and...
Arden Precinct.
Arden Precinct, I beg your pardon, and Docklands. Docklands have got
I
thousands...
don't think I mentioned Docklands, to be fair.
Okay, well, you mentioned... I'm going to mention Docklands because there is thousands of apartments laying empty. What assessment have you done on terms of the vacancy in that particular area, number one, given there is reports that there are tens of thousands of apartments laying empty, and how that goes to your point about affordable housing, because they're laying dormant. And then in terms of Fisherman's Bend, the amenity that is required, infrastructure is required. What is the department doing in relation to fast-tracking that?
I'd have to say I'm not... in relation to the empty apartments, I think the role that we are looking at and what we were here to talk to the committee about is the role of these planning provisions in relation to increasing supply. There are a number of other...
I'm saying there's supply.
I know.
That's my point.
Yeah, well, I think just let the witness finish the question, Mr. McKeegan.
And in relation to supply, there are factors which we can control from a planning perspective around ensuring that the capacity and the ability to have that supply is in place. There are separate considerations to have in relation to how that supply is utilised across the jurisdiction, and the government does have some activities in relation to, you know, how apartments are being used and whether they're active or not. But I think from our perspective and the role that we play, I really wouldn't want to comment on that component. What we are really importantly trying to do is ensure that there will always be some properties that sit within a context where they're not utilised. Somebody may have an investment property where they choose not to put that in the market for whatever personal reasons they do that. We can't control that within a planning context. What we can do is increase supply in a whole range of locations to enable more people to have homes in those different locations. So I don't think that just because somebody doesn't choose to use a property at a point in time should deter us from trying to create the supply.
So
in
why aren't you
appropriate
focused on
locations.
Fisherman's Bend and developing that, which has been on the planning for many, many years?
So the
10
gov-
years of drift.
We are working
So the
actively in the
government's-
development.
Well, why aren't
of
you
the Fisherman's
focusing
Bend
on that
precinct.
and
10 years.
initially?
Nothing.
Because there's just been nothing done. Nothing
There-
done.
11 years, you're in drift.
Okay, I think good answer. Mr. Batchelor.
Thanks, Chair. I just want to clarify a few of the things that have come up so far, because I'm just worried that there's been a bit of a misunderstanding from some of my fellow committee members about the process. Ms Crozier and Mr Davis talked about the declaration of the second tranche of the major activity centres, so the second 50. They weren't included in the recent gazettal
No.
of GC 252, were they? That was just the first 10.
That is correct.
So the declaration is not a term that's used in the Planning and Environment Act, as best I can tell. So it wouldn't be a term of art, but they're an announcement. It's a policy intention rather than a formal planning mechanism. Would that be fair?
That is fair.
And again, Mr Davis talked about horses and carts, particularly in relation to Kew and Hawkesburn. So it'd be fair to say that for those second 50, including Kew Junction and Hawkesburn and the rest of the areas, the consultation process, the in-depth analysis, sort of street by street, block by block, hasn't commenced in a detailed sense yet, has it?
That's correct. At a strategic level, the activity centres across Victoria have been well known for some time. They are outlined within Plan for Victoria. They are identified as strategic locations. But in a sense of going into that detail, the collaboration with local government, identifying the opportunity, that is the part of the program that was announced that needs to occur. And just like that happened with the 10, that then just allows us to do a similar things in relation to those other 50.
And so on the 10, just so I can clarify, they were first announced as 10 pilots in September 2023?
3 as part of the housing statement.
That's right, as part of the housing statement. So we are now in, the gazettals happened this week for that 10 in April 2025, so
On Friday,
on
last
Friday, so that's what, 18 months later. During that 18-month consultation period, you said you had 10,000 submissions, engagement with local councils. Were there any of the local councils covered by the first 10 that the department hasn't spoken to?
No, there's been extensive consultation with all 10.
And has that consultation included both elected officials and council officers?
To my understanding, yes, it
Yes.
has.
One of the other things that you mentioned is that for some time, the notion or the concept of an activity centre has been present in the planning scheme. It's not something as a concept that was introduced into the lexicon in the housing statement in September 2023. Would that be correct? It existed prior to that. How long prior to that? How long has the notion of activity centre been around in Victoria's planning provision?
Look, I've been working as a planner since 1992, and the idea of urban consolidation and building up residential densities in and around activity centres, the language has changed slightly, whether it's a district centre, a NIC, the language has changed, but the concept has been in the planning scheme for as long as I've been practicing.
So it's not a new concept,
No.
this notion that we have parts of our community, parts of the city and regional centres where there are different rules that apply to encourage densification and greater use and development.
Correct.
Would that be fair?
Yes.
And you also mentioned that in some of those existing activity centres, there had been changes or a difference of the way that third-party notice and appeal rights had operated. How long have those type of different provisions, again, in those activity centres, whatever they've been called historically, how long would they have operated? I mean, is it months? Is it years?
Oh no, it's definitely years. The commercial one zone, it came about when the commercial one zone was introduced, which I think is somewhere around 8 to 10 years ago.
So it's not, again, this is not a new concept being brought into the planning scheme, although it might be being applied in different contexts. Now, I just wanted to clarify that. The other thing that we talked a little bit about were the way that in making the determinations in VC 257, for example, and VC 267, that it was a ministerial process was gone through that didn't require, or where the exhibition process that can be excluded under Section 20 of the Act was done so. You mentioned that it occurred before. Where, how often does that occur? What would be another significant change to the planning provisions that had occurred historically, where that would have, where that sort of an exemption would have taken place? You don't have to answer that now, but perhaps on notice if you could.
Well, probably one that comes to me now that, sorry, I didn't think of before, the bushfire management overlay. So when that was introduced to Victoria, it affected all planning schemes, obviously has significant implications for human life, and that was put into the planning scheme without any notification.
So all the changes that have been made to, say, bushfire overlays, for example, were done without that sort of public.
Well, the introduction of the tool was put into the planning scheme without any formal notification. It was done through a 20-part 4 amendment. As to the application of individual overlays within councils, I can't be specific about those.
Just got a short time left. I want to go to some of the detailed work on the activity centres. You mentioned that some of the centres were effectively lifted from existing work that councils had done previously, and particularly we're aware of the case that Camberwell Junction, for example, was effectively just an uplift of pre-existing work from the city of
No, the
Burundanga.
catchment zone was entirely...
Mr Davis, you had your turn.
Sorry.
That was an existing piece of work that had been undertaken by the city of Burundanga over many years.
Correct.
In the core. Were the things in the core that have now been gazetted by GC 252, are they fundamentally different to that prior work that had been undertaken by the city of Burundanga?
The controls are largely the same. I couldn't say it's 100%, but broadly speaking, yes, the controls are consistent with the strategic work the City of Burundanga had done.
And you can take this on notice. How long had the city of Burundanga been engaged in that strategic assessment and strategic planning work at the activity centre core prior to the announcement of the draft activity centres in September 2023?
We'll need to take that on notice.
With 11 seconds left, I'll leave it there, Chair.
Thank you, Mr Batchelor. Mr MacArthur.
Oh, thank you, Chair. Now, these tall tower centres are predicated on the claim that there's a housing crisis. And we know this from the stamp duty and property tax inquiry, that this is almost solely a state government created problem due to almost 50% of the cost of a dwelling now taken up by taxes, charges, regulations, brown, green, red tape. And so that's where the cost of housing has escalated. We also know that there have been at least 120,000 dwellings approved and ready to build on which construction has not begun purely because of the costs involved in the development of these projects. There is no market at the end where these developments could end up in somebody being able to afford a house. So why would a tall towers project in the end produce one more house when we've got a situation where the developers have got the approvals, councils have not been the problem, they've given the approvals, but nobody's going to market because of the cost of building in these areas?
If I can say, I appreciate the current economic conditions, and we are meeting with industry and the development sector all the time in relation to those.
What about the taxes and charges and regulations?
Let's give the witness an opportunity.
In relation to working with industry around the development applications that they have in place, it is certainly something we actively discuss with local government all the time. We actually have within our team a really small group of dedicated planning staff that actually go and work with local government and understand if there are permits that are there. Is there a reason? Some of them do relate to those matters that you discuss, which are outside of the purview of planning and the work that we do. But a number of them, we work with those councils in relation to how we unblock and get some of those permits that may be sitting there that aren't activated if there are matters that are planning related that we work through. Again, I don't pertain from a planning perspective. We are a valuable lever in the ability to create supply. What we don't do is control those other conditions outside of what we do. And if we can create the supply to ensure that there is capacity within our system in a whole range of different locations, what allows that to do is the market to make the decisions around when that is viable and when they can build that. So if we can have more supply, that creates more opportunities for those economic decisions to be made.
If the suburban rail loop doesn't go ahead, will the tall tower centres still be built?
The activity centres that are out on consultation at the moment are based on the fact that you would have significant public transport infrastructure in relation to them. They are a combined housing and transport program. So they would seem to me to be related to having, when you have an activity centre, it's about ensuring that you have really well-serviced, effective, reasonable transportation to those services.
So they won't go ahead? Given there wouldn't be the transport infrastructure available?
That's not for me to speculate. Right. As I said, I think they're a related conversation.
Okay. So, do you know whether Amendment VC 257 was referred to an advisory committee for any of the 10 centres?
Yes, it was.
And was there a report produced?
Yes, it was.
Can we have that, please?
Yes, it's publicly available. Yes. It was released on Friday.
Can you confirm that committee report recommended the introduction of the zone in areas affected by overlays, such as heritage overlay or neighbourhood character?
We'll need to take that on notice.
Yeah, we can make available that public report.
And is it correct that with the new code introduced by VC 267, that council would not have the ability to assess what a development looks like under the deemed to comply provisions?
That's correct. There are 8 standards that seek to influence and control neighbourhood character, things like setback, height, site coverage, tree canopy, for example. But in terms of what the skin of a building looks like, that is not controlled under Clause 55. But in areas where the character of a neighbourhood is important, such as in a heritage overlay, the provisions of that overlay enable absolutely the appearance and form of the building to be considered.
So is it correct that the department and the minister received a recommendation from the SAC report not to apply the housing choice and transport zone to areas affected by heritage overlays and neighbourhood character overlays? That was not followed?
We'll need to take that on notice.
If you haven't complied with all those requirements, how can we have confidence that these tall tower centres will be appropriate? And also, the extra costs of infrastructure that you've referred to, that you suggest council will be responsible for, what costs will council be responsible for?
So as I was saying earlier, there's a mechanism to enable both local government and state government to identify relevant infrastructure within those activity centres, and that enables local government to collect a contribution towards, as we know, infrastructure contributions is just that, a contribution towards key infrastructure for growth within their area.
But that contribution won't cover the costs involved that ratepayers are going to have to pick up the bill for all this infrastructure that you're going to land on local government, will it?
Well, I think if you take growth that occurs naturally across Victoria, so we have a growth projection that's going to happen in Victoria. We need to house people appropriately within Victoria. The targets set an amount of targets for each local government to work with. We need to then strategically work with them to say, where would you apply this growth? The activity centres are just one example of how that growth might be applied, and it's actually about putting it where significant infrastructure already exists, because even in growth areas, there are significant infrastructures that don't exist that need to be funded. So appropriate locations of where we put those activity centres, the work that needs to be done in relation to providing that work can be strategically worked through with local government around understanding within their 10-year growth plans, where would they be putting infrastructure? How would that relate to growth in particular areas? Because if you have them in one location, a council may think that's great because then they can protect other areas within their council and they can distribute that infrastructure cost across that area.
Can we have those growth projections, please?
Sorry, the growth projection?
Yeah.
The
That
growth
you're referred to.
Sure. They're public documents, so that's fine.
Good. What is to prevent inappropriate development in places and precincts with heritage overlays, areas like the walkable catchment zones?
Well, the heritage overlay in itself is an important and valuable tool in guiding a decision maker, a responsible authority, in determining whether or not the built form is appropriate. I know there's been a lot of concern about the impact that the housing choice and transport zone may have on heritage areas, particularly in the Camberwell catchment, which does have a reasonable proportion of that hinterland area within a heritage overlay. It's fair to say that the policies that relate to heritage within the planning scheme are absolutely enlivened. They form part of the layering of the decision-making framework in determining whether or not a proposal is appropriate, recognising that the vast majority of properties within the heritage overlay are either contributory or significant buildings. A permit is required for their demolition. The permit trigger for the demolition of a heritage building does not fall within the housing choices and catchment zone. It falls within the heritage overlay, and it's only the provisions in the heritage overlay that inform the decision maker as to whether or not the permit should be issued for demolition.
Okay, thank you,
luck.
Mrs MacArthur. Ms. Wilkes.
Means nothing, it's just such a meaning.
Can I thank you both for coming and for your presentation today. My first question was about heritage matters and the heritage overlay, so can I just thank Mrs MacArthur for asking the question that I too had prepared to start with. So perhaps I'll jump to my next point, which is about the townhouses code. So in that, I wanted to get some thoughts there about if a site has a heritage overlay, how is that taken into consideration of a townhouse code application? Just thinking about the areas where this might be most popular.
Absolutely, and again, there will be a number of areas of Melbourne where there will be the overlaying, whether it's a heritage overlay or other overlays.
Yes.
The overlays are absolutely an important component of the decision-making framework.
Yes.
Even in a deemed to comply application,
Yes.
where a permit must be granted under clause 55, the decision maker still needs to be satisfied that the objectives of the overlay are still met. So the example that I've been giving with the education pieces we've been doing with local government is take a typical suburban street, it's full of Californian bungalows, it's in a heritage overlay, the average setback is say 9 metres, it's fairly typical for these sorts of streetscapes, but the townhouse code says that the maximum setback is only 6 metres.
Yes.
It is entirely within the purview of the decision maker to be informed by not only the heritage overlay, but what is typically extensive planning policy within the scheme to require that building not only to be set back 9 metres so that it aligns with the predominant setback in the street, but also to require detailed design that ensured that the building was respectful of that broader character.
The character question that we went to earlier. And with respect to the neighbours and these requests, how are neighbours notified? What does that look like for?
So the way in which
community.
adjoining
Has that
property
been
owners are
proposed to
notified doesn't
change?
change. So typically adjoining neighbours and occupiers will get a letter in the mail. There'll be a notice that goes up on front of the site for 2 weeks. So that
Yes.
doesn't change.
So there's no proposals to change that. And what about third-party appeal rights? What's the proposal around that?
For a matter that's affected by an overlay,
Yes.
appeal rights are still fully enlivened in an overlay. So a fully compliant application in an overlay, there would still be full third-party appeal rights afforded to those people.
Okay.
It's only where it's not affected by an overlay that this very strict turning on and off exists.
Okay, so the heritage piece in particular.
Yes.
It might be more a question to councils, and I accept that from the beginning, but do you have an understanding about how many current applications may have been made or intended to be submitted to councils under this new code? Do you have any indications or interest that's come to you?
No, we
since
don't. We
that?
do know that a number of applications have been withdrawn and
Yeah.
applicants presumably seeking to review their proposals in light of the new controls, but we don't have any data per se. It's still too early.
Still too early, right. Do you have any sense about what the impact of these new developments will have on, mostly I'm thinking about if these amendments are revoked, what kind of impacts that may have on townhouse and different development in the areas that are most going to benefit from it?
Well, I think realistically it goes back to the old system where getting approval for medium density housing in typical suburban streets becomes very challenging. And so that definitely has impacted the supply of housing in some of Melbourne's, great suburbs that have great access to jobs, services and
Public
infrastructure.
transport. Do you have any sense then about the time that will be saved on an average application between the old system and the new?
We know that it's an average of 145 days for a medium density housing proposal to be determined. So that's not necessarily a yes or a no, but the decision is made. We see no reason that under the new deemed to comply provisions that the decisions can't be made within the statutory 60-day time period.
But councils are approving the developments.
McCarthy.
Nobody's building them.
Thank you.
Thank you. I might move on to the infrastructure contributions. Again, this was something that was raised by Mrs MacArthur in her remarks. As part of the activity centre plans, how is it that more funding will be afforded to community infrastructure? I'm thinking about transport services, paths, roads, I don't know, schools, community facilities, the things that people want and need to give effect to the great lives that they want in these communities.
We're going to want to get on a bike.
In relation to infrastructure for the 10 activity centres,
Yes.
the ministerial direction change allows infrastructure contribution plans to be put in place for those 10 activity centres
Yes,
for
how
those
does
standard core infrastructure elements, and that allows both state and local government to identify critical infrastructure that's needed within those locations and those areas.
Who's going to pay?
And are they secured to apply to that area under the proposal that you're
It's
talking
within
about?
that's correct, it's within the bounds of that infrastructure contribution plan, which is in that location, yes.
Okay, and where is that captured, just for clarity?
So there's the ministerial direction for the infrastructure contribution plans. Those plans are to be developed up and they would come into play from 2027 to enable time, obviously, for the market to and for the setup of that system and for an understanding of how that would impact on feasibility and decisions within the sector in relation to that, so that those contributions are well known when people make investment decisions within those activity centres.
Right, is any of that available to the public?
Yes, we can make the ministerial statement, which is gazetted, so we can get that available for the
I'd
committee.
certainly appreciate that, thank you. And I might perhaps go to Suburban Rail Loop, which actually it's that question about the public benefit again and infrastructure contributions. And there is the difference, which I think is called something different under the SRL, the Public Uplift Benefit Framework. Can you talk to me about that and how that one works particular to that zone under the Suburban Rail Loop Authority?
Yeah, so in general, and I'll let Colleen add detail to this, but in general, the tool enables the ability to have a benefits uplift framework, and what that framework does, and that's currently out in draft consultation with the structure plans that the Suburban Rail Loop Authority put out at the moment. But it works on identifying where the development sector wants to go above and have an uplift ability, and then for that uplift, there are identified public benefits that can be put back into that area, and that could be
So
something
that
from
proposal is again for that same area, is that
That's
right?
right, and that could be for public realm for that area, it could be affordable housing. There's a range of different benefits outlined within their proposal to enable that to capture that.
So affordable housing is outlined as something. Do you have anything more to add to that? Is there
I think Andrew's probably
targets or
captured
anything?
it
But
pretty
that's
well.
about.
But the idea
that's
is that
it.
when developers are seeking more than what the planning scheme envisages, there's effectively a requirement to give back to the community more broadly, and there's a suite of provisions of which affordable housing is one, and that will be affordable housing as it's defined in the Planning and Environment Act, so not the more broader concept of
What's an
affordable housing.
affordable house?
Excellent. Thank you.
It's defined in the Act, yes.
Okay, lovely. That's all for my questions today, Chair. Thank you.
Thank you, Ms Watts. All right, we've got about 20 minutes left. So we'll just, so thank you to our witnesses so far. Might just do a little bit of a quick move around the table. And I might just kick off. I sort of get the concept of individual buildings and spaces and such like. That seems pretty straightforward. I guess one of the things that concerns me a lot is when we put that at the macro level and we're talking about communities and precincts, as Ms Watts was talking about before. And I guess I'm sort of looking at South Bank, I'm looking at Docklands, and I know there was different authorities in charge of Docklands. I guess most recently, and in my electorate, I'm looking at Joseph's Road in Footscray, which is in the Footscray Activity Centre, which is a disaster. So I know we've got a number of buildings that are all compliant, but in terms of all of the fine words in the policy guide for that precinct, they just don't exist. There's not quality open space, there's not appropriate paths of travel, the streetscape is one step up from Beirut. It's just a disaster. I guess I'm interested to understand what is there in this suite, if anything, of amendments that will prevent the replication of Joseph Street type, Joseph Road style developments and disasters.
Putting aside the challenges that are represented by that particular development, the BFO in particular will be the control that will effectively require detailed consideration of the public realm. The BFO itself doesn't do the heavy lifting, the schedule does, but the structure of the BFO requires a range of considerations, that requires that public interaction to be absolutely considered. So obviously heights is as part of it, but issues such as overshadowing, for example, ensuring that the public realm has good access to sunlight, wall setbacks, that street wall height can be really important in terms of how a pedestrian feels within that public realm, the requirement for landscape setbacks, we've got building separation within the site, that's very important so you don't get that walled in effect as one's experiencing a public space. Wind effects, that's obviously a very important component of feeling comfortable in a public space. There's requirement around active frontages, pedestrian connections, weather protection, landscaping and fencing. So there's exterior design, building services. So the tool itself requires really quite detailed consideration to be required to how a person experiences the public realm.
But isn't that applied to specific buildings? Because it seems to me that where the plot's lost is when you start aggregating them. And I guess I'm in my own backyard, literally, and I'm not being a NIMBY here, but in my own backyard in Kensington, I'm looking at multiple buildings, high-rise buildings, creation of concrete canyons, no open space, no paths of travel, no setbacks built to the boundary. I'm just wondering, how is that not replicated?
So one of the advantages of doing a structure plan, which the BFO will effectively refer to in the schedules, is that it allows that more holistic approach to be undertaken. So the structure plans, if you look at the 10 centres that have been gazetted on Friday, does look at things like pedestrian linkages, looks at overshadowing in a holistic sense, looks at how do we better build connections between existing open space and areas of higher densities. So one of the advantages of the BFO and even the precinct zone tool, for example, is that it does allow a whole of placemaking approach.
Okay, thank you. Mr Davis, a couple of questions.
Just picking up from that, it in theory might allow that, but actually it's in place now, and the structure planning hasn't been completed.
No, for the 10 activity centres,
But
the
not
structure
the catchment
plans.
zones, for example.
But the catchment zones have a different level of density.
I'll come
And
to that.
so because we are looking at typically 1 to 3 stories in the outer parts of the catchment, and I say only 4 to 6 stories, as I said, only 3.5% of sites will
Just
be
let me
eligible
come
for
to
that.
3%. The developers will aggregate sites.
Well, that's true.
Have you
There
modelled
is the
that?
opportunity for lot consolidation.
Have you modelled that?
Well, how do you model
Well,
what?
you could look at previous examples, and is there some modelling on how much, you put two small blocks together and you've got a large block more than 1,000 square metres. So the
just-
answer,
just
I'll
a-
take that as a no.
Well, just to comment on amalgamation, the one thing that the policy does identify is amalgamation allows a much better design solution to being able to achieve the outcome. So whilst that may occur,
So let me
the
come to
policy
that.
does
Hang on,
actually
hang on.
address the ability to, with a larger site, deal with a lot of those interface and other
Let me
matters
ask the
around
questions here. So 1,000 square metres, and you've got just a very small canopy requirement, 20% of the site. So picking up the chair's points before, there's, very significant number of these sites and only 20%. So there's going to be a swathe cut through the canopy in a lot of these suburbs.
Well, I
And
think
cut through, if I can continue, at a time when we're trying to deal with heat island effects. Doesn't seem to me that that's been modelled.
Well, I think firstly, if I can just correct the misperception, 20% canopy cover is actually a very high amount of canopy cover. Plan for Victoria does set 30%.
No, I don't agree with that, but yeah.
If I could just finish. 30% canopy cover is a target that's set in Plan for Victoria across all urban areas, but that includes public land. So the modelling shows that 10 to 20% on lots of varying sizes in metropolitan Melbourne will make an appropriate contribution to that overall target.
But many of these 10 large zones already have canopy in areas that is beyond that, so there will be canopy removed under these approaches.
Well, if we look at the areas that fall within the Housing Choice and Transport Sort 1, these are the areas that are closest to the activity centres. They'll obviously need to be assessed on a case-by-case basis, but that 20% canopy cover will, in the government's view, make a reasonable and substantive contribution.
Yeah, contribution, but a lesser contribution than many
For
of
the
those sites
community.
that have currently got more than that.
Well,
Yeah, that's just
So-
wipe
so-
that away. Let me keep
All right,
going.
maybe a last
Just-
question, Mr Davis, and
Yes,
then we'll
indeed.
come back, and we may come back if we've got
And
more
the
time.
private open space requirement is reduced, as I understand it, in these zones from 40 square metres to 25 square metres. Is that correct? Picking up the chair's point about the tightness and the appearance from the public realm and so forth.
so the amount of secluded private open space remains the same. So the previous controls in Clause 55 required 25 square metres of secluded private open space. The new standard focuses on secluded private open space, but doesn't set a minimum for open space more broadly. But one has to look at that control in the
Down from-
context of the other provisions in the Townhouse Code, which require 60% site coverage within the neighbourhood residential zone and 65% within the general residential zone. There's another control which requires 35% mandatory requirement of garden area. So those controls alone will ensure that there is substantive area that sits around buildings, not only for open space, but also for the planting of tree canopy.
Okay, Mr Blair?
Thank you, Chair. I'd just like to pick up on
I'm gonna go back
something
to that.
It relates to a question I was going to ask, just again in relation to the consultation process that's taken place now. The Chair's given a very good example in Joseph Road in Footscray of what can go wrong and when those things don't happen, and I know that was pushed through back in 2013, back when Mr Davis was the Minister, in fact. That was pushed through by the former Liberal government, and we've now seen the effects of that in Mr Davis's electorate. So the importance, and you've already talked a bit about with activity centres, but I'd like to know in terms of VC 274, the SRL precincts. I know that you don't have any schedule provisions gazetted just as yet, and I'm sure that's because that consultation work is still well underway. Can you talk to me a little bit about the process of that and how you're going to ensure that that consultation process leads to the best possible outcomes for those SRL precincts?
Well, I think firstly we should say that the SRLA are the planning authority for those precincts, so the SRLA will be managing that process, but I think it's fair to say that that is taking a more traditional route. So the structure plans are currently on exhibition. I think from memory, I've been told earlier this week there's been about 300 or 400 submissions lodged across the 6 precincts to date. Those submissions will be reviewed. A series of public hearings will be set up in September and October across the 6 centres. There will be full public hearings where submitters and proponents, the SRLA, will make submissions to the advisory committee. The advisory committee will, at the conclusion of the hearings, consider that, write a report in accordance with normal process, and then there will be changes or not, taking on board that advice, and that will go through the channels, and then put to the appropriate ministers for consideration.
Thank you, and I guess that also covers off why we have VC 274 as distinct from VC 257 because of the unique nature of these sites, and given that they are based on the Suburban Rail Loop project and being managed by the SRLA.
The two amendments are fundamentally the same. They just introduce different tools into the planning scheme. Then there will be separate planning scheme amendments that will then implement the tools.
Yeah, and obviously, as I think Mrs MacArthur was alluding to, the SRL is so fundamental to these projects taking off the ground.
What happens if it doesn't go ahead?
Yep.
Well, that's probably a question for
think
your
it's probably
side,
a little
Mrs
out of
MacArthur,
scope,
and if
but-
Mrs
your
Batten
side,
and Dutton want to
being
explain why they're
Premier
pulling away yet another infrastructure
Scrap it.
project from Victoria, that's up to them to do so, because we know that's what they like to do, is pull away funding. That's
bit-
not
bit of
something for
order,
you to
please.
comment on, though. I won't drag you into the politics of whatever Mrs MacArthur's trying to prove today. But those are a number, and I think there's 6 activity centres under the SRL, and that will be, I know that VC 274 is not explicitly linked to that, but that will be the framework within which those 6 activity centres, including that will benefit the South East as well. So just to clarify that VC 274 is for those 6.
Well, it will be likely used in those 6 centres, but the tool is a standalone tool. It has been identified that there was a gap in the current suite of provisions. The recent planning panel that considered the Arden precinct really exemplified that the current controls weren't really fit for purpose for broad-scale precinct-wide reinvention, and so the zone is in fact a response to that. The fact that it will be used probably in the first instance by the SRL I think is reasonably uncontroversial, but I could see scenarios where it could be applied to other precinct-wide rejuvenation sites.
Great, thank you very much.
Thank you, Mr. Glare. Dr. Mansfield.
Thank you, Chair. Just wanted to follow up on something you said earlier, I think again with respect to VC 267. You said that the tribunal need to make an interpretation in the period ahead about what compliance with the standards means in detail. Has the department modelled what, impact this is going to have on in terms of pressure on the tribunal or in terms of delays that this might create in the overall speed of decisions that would be made under the code?
We've certainly put together an expansive, decision document that's on the website that gives it's 80 pages, so it gives quite extensive explanation about what the standards are and how they are to be implemented. So that work has been done to guide not only local government but also the community and other decision makers like the tribunal. So that work has been done to provide guidance as to how the standards should be implemented. We've certainly undertaken consultation with the tribunal. We've presented the provisions of the Townhouse Code to them. I think it's fair to say that they would expect in the first 6 to 12 months of the code there to be some testing some of the provisions. They're working within their own internal decision making as how they're best placed to deal with those initial requests. But there's an expectation that once that initial testing of the provisions is completed, that it would actually result in far fewer applications
So
going
there
to
could
the
be some
tribunal.
delays in the short term, potentially.
Not delays. A lot of the initial queries will probably be dealt with through what's called practice day hearings, and they're dealt with quite quickly.
Okay. All right. And just with respect to the, again, with VC 267, the tree canopy requirements, 10%, I guess I'm just interested in how you arrived at that figure. What, benchmarking, modelling informed that, what impact is it going to have on established trees and established vegetation compared to the previous, provisions around vegetation?
Yes. So to be clear, the requirement for vegetation more broadly to be integrated into medium density housing is still there. There is still a requirement for a landscape plan. So the objective that deals with the design response still requires a landscape plan, and there's some fairly detailed prescription there around the sorts of issues that need to be taken into account. So for example, vegetation that's suitable for local conditions is part of that decision making, need for irrigation, quality of soil. So that is still dealt with within the code. That would typically be dealt with through a condition 2 that requires a more nuanced conversation between proponents and councils as to what is a fair and reasonable landscape response. In terms of the 10 to 20%, I'll need to get back to you about how those figures were derived, so if I can take that on notice.
Thank you.
All right, terrific. Got a few minutes left, so we'll just have a couple of quick questions, starting with Buffed here. We've got activity centres created through 257, 274. We've also got the existing activity centres. To the degree that there's an overlap, does the new activity centres extinguish the existing regulations for those activity centres that were introduced in 2018 or whenever it was?
No, because these are just overlays. So the zone provisions remain untouched, whether it's the 10 pilot centres or the 50 that have been identified. The underlying zoning remains unchanged. The BFO is used to, for the core. The BFO really then guides the built form and public realm outcomes. The change in zoning occurs for the catchment areas, and that changes it from what would predominantly, I imagine, would be a general residential zone. That would be the likely zone.
And neighbourhood zones, which have been emasculated.
So for the majority of centres, the general residential zone would be the dominant zoning that surrounds these areas. Mr Davis is right, the neighbourhood residential zone would be the likely dominant zone around the Camberwell Activity Centre.
And others. Glen Ira too.
Okay, thank you. Please.
So the housing choice and transport zone remains a residential zone, so the land use expectation is still reasonably the same. The difference is, of course, the development outcomes. And as I say, those development outcomes decrease as one moves further away from the transport node.
Thank you. A couple of quick last questions.
Yes, very quickly.
Ms. Crozier?
Just on the canopy 20% modelling, could we, for all the activity zones, could we have the current canopy coverage, and then where the expected 20% is, where the 20% is expected to occur within those sites?
If that is available,
Yeah.
we'll provide that on notice.
We certainly have tree canopy cover at a municipal level, but I don't think it goes down to smaller
But
precincts.
it is going to be impacted, so surely you've done some sort of modelling given that 20% coverage that you spoke of. So where is that expected to occur?
If it's available,
now?
we'll provide
What is
that.
it now and where is it going to happen? Thank you.
Okay, we'll
And
take
the
one last
same on
question, Ms.
heritage
Watts.
would be valuable.
And
The
the
same-
same-
Sorry,
the
yeah.
Ms
same on
Peterson, I
heritage.
just had a question about VC 267 and the ESD standards around solar energy. What changes have been made to improve access and take-up of solar energy under this code?
So that's two of the key changes. So there are two separate standards. One recognises the protection of existing solar energy on adjoining sites and protects them from overshadowing. I think from memory the provisions are to be free from shadow between 9 and 4 p.m. at the September equinox.
Okay.
The second, so that was a gap that had been missing under the previous controls. Another standard then also requires room to be available on the roof of medium density housing to provide a set minimum area per dwelling for energy. And it doesn't mandate that solar energy be required, but it requires that consideration be given so that the orientation of the building, for example, would allow that to be maximised on the site.
All right, we're going to leave it there. So can I firstly thank Ms Peterson and Mr McKeegan for coming in today and subjecting yourself to the process. It's much appreciated. And we will, I'll just advertise that we will be looking for probably a follow-up on the 30th. I think you've been advised of that probably, just to close out the process. So thank you, Mr Davis, briefly.
And there's a number of follow-up items.
I'm going to come to that. We'll actually convene a meeting briefly
that's
when the witnesses are finished. Can I just draw to your attention that you will receive a copy of the transcript for review in the next couple of days before it's published on the website. We'll take a break now until till 1:15 when we'll be back with Dr. Stephen Rowley. So we'll end the broadcast at that point. Thank you.